The first matter to come before the court this morning is State of Ohio versus Charles Mills. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and would like to reserve that time, if you let me know, I'm keeping the clock this morning. We've read the briefs and we are ready to proceed when you are.
Morning. I'm Wesley Johnston for the appellant. I'd like to reserve 5 minutes if I could. This case is a substantially gruesome case. There's no doubt about it. The charges that are involved here are terrible. The alleged behavior is terrible. The case was charged as a rape case of the pandering charges. There was a plea in this case. There was some issues at the plea, but there wasn't anything that would be substantial enough to warrant a withdrawal of the plea. The issue for my purposes is whether or not consecutive sentences should have been ordered in this case, and if they were ordered, whether or not there was sufficient indication by the court in the journal entry to warrant that, to justify that. As the court knows, when ordering consecutive sentences, there's no need that the court go into or explain what particular things it relies on for doing that. It can just basically indicate what the statute says and then justify the consecutive sentences. In this case, though, I believe the court failed because it did not enunciate basically what I believe is a two-part question. First of all, you have to enunciate that prison terms are warranted in the case. The second thing you have to do is you have to justify the consecutive sentences through the statute. In this case, I believe that that was not done. From the journal entry of the case, there's three basic issues that I find at issue with the journal entry of this case. The first issue is that the court does not indicate, basically in the order of the court, it indicates that it wants to do consecutive sentences. When it orders the consecutive sentence, it then subsequently talks about the sentences being that a prison term should be warranted. And I don't believe that that's an appropriate way for the court to do the balancing test, or I would call the staging of the test. I think, first of all, the court has to determine whether or not prison sentences are warranted under the general principles, then go into whether or not consecutive sentence is warranted. And I don't think it does either of those.
So you're complaining of the order in which the court articulated its decision?
Absolutely. One of the issues that I'm complaining about is that there is a failure of the order, and basically how the court went into, from the journal entry, how it went into the findings.
So it can't give its conclusion and then follow up with the ABCD findings. It must give the ABCD findings and then conclude?
Your Honor, I believe that, I think that's accurate. I think the issue is that because when it finds there has to be consecutive sentences, that presupposes that it found that prison term was appropriate under the standard. In this situation, the court basically says, after it imposes the consecutive sentence, it says prison term is then appropriate in this case. And I believe that's inappropriate. The finding has to be graduated. It has to be, in the first situation, we have a situation where prison has to be required. Then it has to be a question of whether or not consecutive sentences are warranted. And I think the journal entry on itself does not do that. And I think that's inappropriate. The reason why I say that is because there shouldn't be a situation where when you say prison terms are consecutive, there shouldn't be an assumption that therefore then prison terms are warranted. That shouldn't be the way. I think the court has to first determine, i.e. prison terms are warranted, and i.e. consecutive nature of that, if warranted. And I think that that's in the statute. I think that's certainly something that, in this case, the court did not do. And second issue, Your Honor, if I could talk a little bit about, was the court talks about, in its journal entry, it talks about future harm when it should state specifically the statute talks about future crime per the statute. That's important because the statute for the consecutive sentences requires that the court talks about future crime. Future harm is not crime, and that does not mean that someone is going to commit a future crime. Doesn't mean that someone is going to be charged with a future crime. Doesn't mean that somebody's going to engage in future criminal behavior. Doesn't mean anything of that nature. I looked it up, and I don't even think future harm is defined anywhere that I see. What the statute talks about for consecutive prison terms is future crime for the statute. That was not done. When I look at the statute, when I look at the journal entry, it does not talk about that. It talks about prison terms are necessary to protect the public from future harm, and that 2 more of the offenses were committed as significant. And I believe that that is some issues. Final thing, if I could, this kind of goes back to what I was talking about earlier, the reference in the entry to prison term adequately punish the offender. That kind of language needs to be directed not towards the issue of consecutive prison terms. It needs to be directed towards whether or not a prison term is warranted under the initial findings or whether by the court. So it's my opinion that the journal entry in this case, the sentence in this case should be vacated. There's 3 flaws that I find in here that are contrary to law. Yeah. Thank you very much. If there's no questions.
Good morning, Your Honors. My name is Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney, and I represent the state of Ohio in this matter. May it please the court. I find it a little interesting that this morning the argument seems to have morphed from the brief. The captioned assignment of error in this case was that the trial court failed to expressly state its findings as required in 29-29-14 and restate those findings in the subsequent judgment entry. Today, the argument is that the trial court erred in the order in which he made findings and decided to impose a consecutive sentence. To the extent that the argument today is beyond the scope of the captioned assignment of error in the brief, I think that the court should decline to address under 12A2 of the appellate rules the argument today. If, however, the court were to go on to consider the argument today, I'd note that nothing in State v. Bunnell from the Ohio Supreme Court last year requires the order in which the trial court is supposed to make findings and decide to impose consecutive sentences. Indeed, the very decision-making process at issue underlying the policy and principal purposes in 29-29-11, 12, and 29-29-14C4, the consecutive sentence provision in the revised code, there is no requirement in terms of the order in which a trial court is supposed to conduct that sentencing hearing. Nothing in 29-29-19, for example, which specifies the underlying procedure for felony sentencing in Ohio, specifies any particular order in which that's supposed to happen. So to the extent that the appellant's assignment of error, the argument today, challenges that it's contrary to law, there is nothing in the law for that to be contrary to. The requirement in 29-29-14C4 is, and as the Ohio Supreme Court has told us in Bunnell last year, is that the court has to make those findings under 29-29-14C4 in support of a consecutive sentence. And here the trial court very clearly did so. As noted in the state's brief at page 10, referring to the sentencing transcript at page 17, the court found that consecutive sentences were necessary to protect the public, that they were not disproportionate to the seriousness of the conduct at issue, and then made one of the alternative A, B, or C third findings. It found that 2 or more offenses were committed as a course of conduct and the harm caused was so great or unusual that no single term could adequately reflect the seriousness of that conduct, which is the C4B factor. The trial court very specifically makes that finding, page 17 of the transcript, and incorporates that finding into its sentencing entry. It fully complied even before. I'll note that the sentencing entry in this case, it was journalized before the Ohio Supreme Court's decision in Bunnell, but it still fully complies even with Bunnell applying in this case. The trial.
Explain to me how the judgment entry fully complies. I realize it was journalized prior to Bunnell.
Mm-hmm.
We have necessary to protect the public from future harm.
Mm-hmm.
So one finding.
Mm-hmm.
That 2 or more of the offenses committed part of the same course of conduct,
Mm-hmm.
and the harm caused was greater than usual. That's one finding. That's the third finding. Trying to find the second finding, unless, of course, it's the prison term of this offense will adequately punish or protect the public. It seems to me that when I look at it, we might have a first finding and a third finding twice, but no proportionality finding in the judgment entry itself.
Well, and I would note that Bunnell in paragraph 29 specifies that the language of the sentencing entry or the language of the finding at the hearing need not use talismanic words or necessarily restate exactly or precisely the language of the statute. So if you find that the second factor or the second finding is incorporated in the entry, it's just not the particular language of the statute, that is sufficient. And I'll note that page 2 of the sentencing entry here, the court finds consecutive prison terms are necessary to protect the public from future harm, and that 2 or more of the offenses were committed as part of the same course of conduct. So we have the first and third. And that the harm caused was so great or unusual that a single term is not adequately, okay, so continuation of the third. In imposing the term, the court made the following findings. Prison term of this offense would adequately punish the offender and or protect the public from future crime. I believe that even if the court does not specifically use the word proportionality or disproportion in terms of finding that the sentence was not disproportionate, in talking about, right, that's the second required finding that Bunnell lays out and that the flush text of 2929 14C4 identifies, that the consecutive sentences would not be disproportionate to the seriousness of the conduct. In talking about the seriousness of the conduct and making that kind of determination, that consecutive prison terms were necessary to protect the public, and talking about the course of conduct and that the harm caused was so great or unusual that a single term does not adequately reflect the seriousness of that conduct, that I think that language, even though it's more specifically tethered to paralleling the third finding, that additional finding is also sufficient for the court to find the second requirement under 2929 14C4. In talking about the seriousness of the offense, it's clear in considering the principles and purposes of sentencing, in determining to impose a consecutive sentence, the trial court was very clearly considering the need for consecutive sentence. It made that finding that it would not be disproportionate. It just did not use the specific language of the statute. And under Bunnell, paragraph 29, that's sufficient.
And because it was journalized before Bunnell, if it's read to not include that second finding, assuming that, because it's before Bunnell, what happens?
Well, I don't think that there's really any contention that Bunnell does not apply because this was journalized before. I think that Bunnell, because this case was still either pending or on direct appeal at the time Bunnell was decided, I don't think the state has any contention that it does not apply. If the court were to find that the court failed to make the second finding and to incorporate it into its entry, the remedy under Bunnell is that as long as the court made the finding at the hearing, it can correct the entry non pro tunc. And that's argued in the state brief, I think at around page 9 or 10.
Can it correct it non pro tunc, or must it re-sentence?
It can correct non pro tunc. Actually, the Bunnell decision cites to State versus Qualls on this point, which I think Qualls is a post-release control decision, but in talking about the ability to correct non pro tunc, the Bunnell court very specifically holds that as long as the court made the required findings at the sentencing hearing, the failure to incorporate those findings into the sentencing entry, although it should do so under the statute, does not render the entry non-final. It does not cause the sentence to be contrary to law and void. It just requires correction to reflect what the court has actually decided. And in that sense, criminal 36 and non pro tunc is the correct manner to proceed.
Because the findings were made at the sentencing hearing.
Correct. And the record very clearly bears that out. Page 17 of the sentencing hearing, the court is very clear that he's making all three findings. He intends to make all three findings to impose a consecutive sentence. To the extent that the court identifies any issue with the entry itself, but now holds that non pro tunc would be the proper recourse there. If the court does not have any other questions, I would yield that balance. Thank you very much.
Counsel, you have your full 5 minutes of rebuttal.
Thank you. I want to talk a little bit about the question of whether the court spoke about proportionality. I don't see that it did in any situation. Also, with respect to whether or not a non-pro tunc can cure an entry of this nature, I don't feel that it can. There is some case law on this issue. Bunnell spoke on this issue, but there's nothing clear that says that, for instance, there's a case, State v. Miller, non-pro tunc order cannot cure the failure of a judge to impose restitution in the first instance of that sentencing. But it seems to me that the failure to make required findings could not be cured. This is not something that can be modified by non-pro tunc. It can be cured by non-pro tunc. I don't see any case law to that. And the case law I see that says is that something of this nature cannot be done by that nature. With that, I thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and the Supreme Court website.